thank you very much. Now today, as I said, is a day of plain language. It's funny how words can be so complex and so nuanced. Maybe I should give this example, but I believe that Commissioner Gray, if you were, I asked him what the simplest and most easy to understand word was in the city of Wilmington, and he said, duck. And if you were to utter that word in the streets of Georgetown, Commissioner Conaway would tell you that people would look their eyes to the sky. So words are important, and I know we're going to get a lot of edification from people today about what may means and what included includes and excludes. So I want to thank council in advance, but just remember it was some lawyer in the legislature that wrote these statutes for our legislature, so there's a lawyer to blame somewhere. And it's unfortunate that given the amount of time that's passed, that someone has not sought to convince the legislature that maybe they should end this continuing battle we have over the language. And I doubt very much that whatever decision we make today will be the end of the battle, because it's a very important decision, and a lot of people are interested in this decision, so I expect that we'll probably be a continuing saga. I would say thank you to all the members of the public that wrote in, got a lot of input from members of the public. I'd say 99% were for the inclusion of Bloom Energy in terms of the calculation we're going to discuss today. Obviously, some of that was, instituted by people with an interest in this hearing. And of course, the general public will be welcome to speak today. We have, I think, the staff and the DPA, Mr. Myers, whom I would say presented really pretty long and
don't say boring.
no, not boring, long, but informative briefs. We also had very important input from other entities, the Cesar Rodney Institute, et cetera, all the people that will be speaking today. So I did have some ex parte discussions on the issue of how we're going to proceed today. And as a result of those discussions and input, I think that the best way to proceed was to make sure that the parties who filed the major documents in this case will have sufficient time to talk. We're going to give them 15 minutes. And then the other ones who filed shorter documents would have a period of 3 minutes to discuss their issues. And if someone has a particular problem with those limitations, you're free to talk to us up front about it. But the bottom line is that this issue, or these issues, have been run through this commission before. These commissioners are familiar with the issues. We have received, as I noted, a lot of legal opinion and citations, precedents, all of which we appreciated, so that arguably arguably oral argument's not necessary, but we do want to hear from everybody because it is a very important matter. So if we could have, at the appropriate time, we'll go into that. But right now, obviously we need to finish the rest of the agenda. So we have the consent agenda. Was the first thing on the agenda. Are there any commissioners that wish a matter on the consent agenda to come off, or any questions? Commissioner Gray? No?
No, I was going to make a motion, Mr. Chair,
Okay.
that we adopt the consent agenda as submitted.
I second it.
Is there any discussion on the motion to adopt the consent agenda? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. The regular agenda, number one is in the matter of the application of Delmarva Power and Light Company for a change in natural gas base rates and miscellaneous tariff changes. The commission welcomes Mr. Goodman and his new associate, Mr. McCann.
I think you have it backwards. I work for her.
Connie, you don't want to sit next to,
He held the chair.
If I had to choose who to sit next to. Thank you, Chair and Commissioners. This is, it's funny, on the agenda it says, you know, the rate case, and you're probably wondering, I thought that was resolved long ago, and it is. This is an agreement that came out of it, that the parties to the rate case, which in this case were DPA staff and Delmarva, would work together to look into potential of microgrids, and even if the decision is not to do one, it'll be a great learning experience and a way to report to the commission on these things. And one of the things, the first step that we agreed to was to reach agreement within 6 months on what the scope of it would be. And there have just, we're not running into disagreement, it's just there was, I guess, more issues than expected. And rather than push it and not get the thing we wanted, Ms. McDowell came up with a quite brilliant suggestion that let's do this right and seek an extension to come to agreement so we can get something that's going to be a better result. And we absolutely agreed, and she was kind enough to put together an order that we agree with. So I don't think anyone has any issues with it, but I'm sure they'll speak up if they do. We're just asking for to push the schedule back about 2 months, again, just so we can produce something that's going to be more beneficial to everyone.
Ms. McDowell?
Yes, Connie McDowell for commission staff. And what Mr. Goodman has said, I agree with, and the staff would urge you to adopt that order 9152.
Ms. Iori?
Thank you, Chair Winslow and Commissioners. The DPI also agrees with the proposed form of order and would ask that you, the Commission, enter it.
Thank you, Ms. Iori. Mr. O'Brien? He agrees. He's shaking his head yes. Is there a motion with respect to proposed order 9152?
Move we approve order number 9152 as presented.
Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstention? The motion carries. Thank you, Ms. McDowell and Mr. Goodman.
Thank you.
Number 2 is in the matter of the application of Chesapeake Utilities Corporation for approval to extend the cost recovery period under its temporary gas storage tank program for the Peninsula Lakes subdivision.
Thank you, Chair Winslow and Commissioners. Bill O'Brien on behalf of Chesapeake Utilities Corporation. With me today, I have Shane Brakey, Director, Energy Services for Chesapeake Utilities. He's available to answer any questions if you have any. I'll try to make this quick so we can get to the plain language portion of the agenda. But what this is if you recall, at the end of 2016, you approved a settlement agreement in Chesapeake's last rate case. And one of the components of that agreement was authorization for the company to include in its project costs certain costs associated with providing a temporary gas storage service to potential customers prior to our getting our gas main to a new development. The company had experienced some projects that were unable to go forward because the developer was ready to serve their new customers, their new homeowners, with service before we were able to get our gas service main to the development, even when those projects were economic. So what the commission did was authorize the utility to have a temporary gas storage service in effect for 12 months prior to us getting our gas main in. But what they did was they allowed an additional 6 months on top of those 12 months of recovery in those situations when a project went beyond 12 months for reasons that were outside of the control of the company. So you do have before you proposed order number 9151, which would authorize the company for one particular project near Millsboro, the Peninsula Lakes project, to add those additional 6 months to the cost recovery period. We made this request a couple of months ago. Staff served some discovery. They confirmed or verified that the project still met the economic test of the company, meaning that existing customers were not going to be subsidizing the cost of this expansion project, and put together this order for you today. And that project is Peninsula Lakes. It's near Millsboro, Delaware. The order is largely self-explanatory, but the primary reason for the delay is DelDOT's restrictions in the summer on road construction along Route 24, which is a popular route to the beach in the summer. And because of those road restrictions and a couple of other things that are mentioned in the order, the company was unable to get that main extension project completed within the 12 months. So we are here just to ask you to approve Order 9151, and Mr. Brakey is here to answer any questions that you might have.
Thank you, Mr. O'Brien. Mr. Willard?
Yeah, everything Mr. O'Brien said, we agree with. Again, obviously, the economic test he referred to is intended to confirm that the anticipated revenues from the project will exceed the overall cost, and so customers won't have to subsidize it, as he said. Excuse me. And again, as he said, the reasons for the extension is DelDOT says you have to shut down from May 1 to October 1, because this is a very heavily trafficked area for the beaches, and so they couldn't do it. And also, they also discovered that a majority of the right-of-way was under the shoulder of the road, where normally it's next to the road. And because of those two items, they need some more time to do this. And they have said, excuse me, they intend to finish this by June 20th, 2018. So with that in mind, then the staff also recommends that you approve Order 9151.
Ms. Iori?
Thank you, Chair Winslow. The public advocate supports the application and proposed order number 9151.
Thank you. Commissioners, any questions?
Yes,
Mr.
Mr. Chair.
Gray.
Mr. Chair, one question. I also agree with the order, but I wonder, I don't see the date in the order for the June 20, which was mentioned, and I'm wondering, should it be there in the order before we actually finalize this?
Let's see. Well, I think, Commissioner Gray, it may suffice that the order says that the recovery period is extended from 12 months to 18 months. We certainly have on the record through the application and Mr. Smith's memo that that date is June 20th is what the 18 months goes to. So I'm not sure we need to change the order.
Okay, that's fine. So on that basis, Mr. Chair, I propose that the commission adopt order number 9151 as submitted.
I second it.
Any discussion on the motion? Hearing none, all in favor signify by saying aye.
Aye.
Are there any opposed, any abstentions? The motion carries. Thank you, Mr. O'Brien. Thank you, sir.
Thank you.
Number 3 on the agenda is in the matter of the application of Delmarva Power and Light Company for approval of a program for plug-in vehicle charging. Mr. Goodman.
Thank you again, Chair and Commissioners. This is an application that was filed several weeks ago, back on October 19th. It is an application by which Delmarva Power is trying to, get the ball rolling, or should I say get the wheels rolling, whatever pun I can come up with, on trying to address the desire of the state and many of our customers to make it easier for folks to actually use EVs, electric vehicles throughout the state. There's also a very important planning perspective to this as well. These direct chargers, fast chargers, have an unbelievable initial load. It gets pretty dangerous if you're trying to shove a baseball down a garden hose for a short period of time. So we really need to learn about the planning that's going to be necessary for the system to address what we expect and actually hope will be a very successful new technology. I think it offers a lot to the state in the form of saving customers an enormous amount of money. I think even some of the worst, most inefficient electric vehicles like the super fast Teslas that I know, at least one commissioner here enjoyed driving the other day. They still get about the cost equivalent of 90 miles per gallon. And so when you get into the more efficient ones, it's really stunning. So it's the opportunity to save customers a lot of money. I know our friends at DENREC support it because the #1 creator of emissions is transportation. And so when we can have zero emissions vehicles, you're really cutting back on that as well. So this is going to give the commission and the public opportunity to help develop the plans on how we're going to move forward. And we have an opening order here drafted again by staff. They were very conscientious to accept some requested clarifications on behalf of all the parties. And we have before you what I believe is an agreed upon order. It simply opens the docket and sets dates for noticing public comment sessions. And with that, other parties will speak, but Delmarva requests that you execute this order and open this docket so we can move forward.
Thank you, Mr. Goodman. Mr. Willard?
Again, as Mr. Goodwin said, but also, there's 3 different types of residential ideas that they're proposing, and another one for multifamily dwelling units, and then 2 for public charging for these electric vehicles. This is just to open the docket, of course, and it provides for Mr. Hay to be the hearing examiner and written comments to be submitted by February 28th. Parties may intervene up until January 12th. And there was one thing about this. The notice that we had attached to the order originally called for 1 public hearing in the city of Dover. The DPA pointed out that Delmarva does business in all 3 counties, and there should be public hearings in all 3 counties. And we have now changed that public notice attached to the order to call for a public meeting in Newcastle on January 16th, in Dover on January 17th, and at Indian River on January 18th. And with that, the staff recommends approval of order number 9150.
Ms. Ivory?
Thank you, Chair Winslow and Commissioners. The DPA thanks Delmarva for its public service announcement there with respect to what's in the application. We hope that minds will be kept open because not everybody thinks that this is such a great idea. But the docket is being opened, and we will make our comments by the time provided for in the order. And we do thank Delmarva and the commission staff for putting in the other 2 public comment sessions. Thank you.
Thank you, Ms. Ivory. Tesla's got some convertibles, too. Very nice in a Tesla convertible.
Way out of my price range.
Yeah, I agree with you.
I'm a
on that.
state employee.
Well, thank you for your cautionary comments, and it's going to be interesting to see as we go forward what happens. And so I think the commission is eagerly looking for the results of your work in this particular project. So thank you all very much. Commissioners, any questions?
One quick question, Mr. Chair. The scope of what this is going after seems pretty much residential and public. I'm just wondering, is there any focus to be given to fleet potential for EV charging and its impacts on infrastructure? You know, we have Amazon, Federal Express, U.S. Postal Service, and so on.
Your Honor, I believe that is indeed part of this. And if it's, obviously, if that's something that should be looked at that's not in here, I will note that it will be added, because I think it should be. Again, I apologize, because this was originally put together by my good friend and colleague, Pamela Scott, who has in private practice now. So I'm not as up-to-date on this filing as I would normally be. So I don't want to give you an answer that I can't know.
Okay, I mean, it's not critical today, but it's food for thought, because, I mean, even school bus fleets represent an opportunity where if you connect all of them to the infrastructure, you might have to do some changing. So-
City buses as well, that's
Yeah.
one of the best, so our residents of these cities don't have to breathe in some of that diesel. So, yeah, I can say with almost 100% security that that is part of this, but if it's not, we will report back to you,
Okay.
so you're aware.
So, Mr. Chair, on that note, I'd like to move that order number 9150 be adopted as submitted.
I second.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you all.
Thank you.
On the hearing schedule is the first one, and the only one is in the matter of the adoption of rules and procedures to implement the Renewable Energy Portfolio Standards Act. Would the parties who have intervened kindly come to the table? Mr. Stevenson, I noticed that you came in just after I had finished some comments, and ordinarily I wouldn't make comments about something so far in advance, but I did make a couple of comments about this matter while you weren't here. You have 3 minutes to talk, sir.
You'd like me to go now?
No. When you talk, because what I'm doing is I'm I shouldn't say the major players, but the entities that produce the most paperwork, so to speak, are getting the most time. And the other documents were great. I mean, we appreciated your input as well, but I don't believe you need as much time as some of the other
3
parties.
minutes is fine, sir. Thank you.
Thank you. So I think we should start with Mr. Walsh.
Thank you, Chair Winslow and Commissioners. As you're aware, Mr. DeLosa was the author of the memorandum of support of our proposed regulations here for Reg 56, and I would like to, since he is far more familiar with the intricacies and potential questions that the Commission may have, I would like to have him present the 15 minutes on behalf of PSC staff.
14 minutes and 30 seconds.
Okay, thank you, Mr. Walsh. Good afternoon, Chair and Commissioners. First, I would like to start off by thanking the other parties in this docket, which really submitted thought-provoking and deep comments that the Commission staff spent considerable time looking over and ensuring that our proposed regulations, to the best of our ability, would reflect those comments. But as far as the issues before you today, I'll kind of jump right in. So as you know from the issues list, the first issue is what is the total retail cost of electricity for retail electricity suppliers? Staff's position is that the only way to get to total retail cost is to include all of the supply, transmission, and distribution costs that are made at retail to end-use customers. The first question, of course, is who is a retail electricity supplier? REPSA provides the answer. It's a person or entity that sells electrical energy to end-use customers in Delaware, including but not limited to non-regulated power producers, electric utility distribution companies, and other entities. Now, there are a few important points to note in that definition. The retail electricity supplier is the entity that sells electrical energy. Others may attempt to distinguish between the supply and distribution roles of single entities, but the definition is clear that the entire entity is to be considered as the retail electricity supplier. The second is that retail electricity suppliers sell energy to end-use customers. Others will accuse staff of trying to engraft the language of end-use customers into the definition, but staff would point out that retail electricity suppliers are in fact defined by their sales to end-use customers. If you don't make a sale to an end-use customer, you're not a retail electricity supplier. Third, distribution companies, specifically in their role as distribution companies, are retail electricity suppliers. And last, there can be more than one retail electricity supplier selling to an end-use customer at once. And I'd be happy to elaborate on that if the Commission has questions. The next question at issue in this definition is what is the total retail cost? Now, retail costs are those paid by end-use customers. The definition of end-use customer in the REPSA supports that. That end-use customer means a person that purchases electrical energy at retail prices. Reason would dictate that the total amount of sales at retail would dictate the total retail cost. This again would illustrate that the total retail cost is the total of all sales to end-use customer, which are the only sales at retail. Lastly, what does the word "for" mean in the definition? Staff and in our memo essentially narrowed it to two different considerations. Is it the cost for buying electricity of the retail electricity suppliers or for selling? The former is precluded because those would be wholesale transactions. Those would be when the retail electricity supplier purchases for resale. That is not allowed, as the definition requires total retail cost. Staff's interpretation is also bolstered by the remand opinions directive to not collapse distinctions in the statute where they may exist. Section 363 provides what I'll call special provisions for municipalities and co-ops, and I'll go to this now and one other time. It provides a useful point of comparison to determine whether there are any distinctions that need to be given meaning in the regulation. These special provisions for munis and co-ops provide an analogous section of the statute, and they use the term, quote, "the total cost of the purchased power of the utility." Now, this is substantially different from the term total retail cost of electricity for retail electricity suppliers. The special provisions text clearly only illustrates the wholesale cost for the retail electricity suppliers. As the text is different in the Delmarva cost cap, the remand opinion would instruct to give some different meaning. With respect to the Bloom issue, at issue, as you're familiar, is whether the cost of Bloom should be included in the quote-unquote cost of complying with the RPS requirement. Staff's position is that Bloom should be excluded from the calculation, and we have two reasons for that. The first is that the plain and ordinary language, on Plain and Ordinary Language Day, does not provide for the inclusion of Bloom in the calculation. And second, the statutory distinctions, as I mentioned before, will further support staff's position. So the opinion directs the commission to interpret the plain and ordinary meaning at page 11. In doing so, staff's proposed regulations properly limit the list of items to those specifically included in the statute. Now, while Bloom does, as Mr. Myers and the DPA state, it does fulfill a portion of the RPS requirement, there is another section of the REPSA that specifically characterizes how this Bloom output may, quote-unquote, fulfill these requirements. This is in section 364D, which reads, "The Qualified Fuel Cell Provider Project, or Bloom, entitles the commission-regulated electric company to reduce its REC and SREC requirements as provided for in the section of the statute that provides that Bloom may fulfill the RPS requirement." However, Bloom is not an eligible energy resource. Others here will likely ask you, if it walks like a REC and quacks like a REC, it will be a REC. However, as we know, the Bloom amendments substantially altered the REPSA in 2011. If the General Assembly wanted to make Bloom an eligible energy resource, it would have been much simpler to simply amend the definition of eligible energy resource to include Bloom. The General Assembly made a choice. They amended 15 sections of the REPSA and did not change the definition of an EER. That would have been a much easier path for them to go down if they wanted Bloom to produce RECs. Instead, they took on an entire new construct to create something that clearly is not an eligible energy resource. Now, the opinion also directs the commission, as I mentioned, to not collapse the plain and presumably intentional distinctions where they may exist. Staff would like to offer you two presumably intentional distinctions. The first is from the special provision section that we discussed before for municipals and co-ops. In that section, that cost cap provides a catch-all phrase in the form of, quote, "or other costs incurred," or other costs incurred in meeting renewable energy programs. So for the special provisions, they list out, just like the Delmarva cost cap does, and then they add on, or all other costs incurred in meeting these programs. Now, if such a phrase were included in the Delmarva cost cap, the Bloom issue would not be an issue. That catch-all phrase would catch everything else, right? However, the Delmarva cost cap specifically enumerates the different pieces that should be included. This distinction, where the special provisions include the catch-all and the Delmarva cost cap does not, is a substantial and presumably intentional statutory distinction that should be given meaning when the commission interprets the reg. The next presumably intentional statutory distinction is resides around the word includes. As you know, the cost cap, the word include, is found in the cost cap as follows. The total cost of compliance shall include, and then the list follows from that. Distinctions within REPSA must be given meaning. Now, with respect to REPSA, when the legislature means include to be non-exhaustive, as what I mean by that when I say include, there may be other things added in. When the legislature means that, they use the phrase including but not limited to. They do it 7 times in the REPSA, and I have the cites if you'd like it. In contrast, when they use the term shall include, it is limited. A great example is in the definition of eligible energy resources. The definition of eligible energy resources reads, let me find it here. Eligible energy resources include the following energy sources located within or imported into the PJM region. Now, if that list were subject to expansion, you could have coal or nuclear or natural gas producing RECs. But that list is not subject to expansion. And the include language in the EER definition is much more similar to that in the cost cap than the including but not limited to, which is used elsewhere in the statute that allows the list to grow. The last topic, as you're familiar, is whether or not there is discretion, and if there is discretion, whose discretion that is in freezing the cap. So the first issue, the threshold issue, is whether or not there is any discretion in a freeze of the RPS. Staff's position on this threshold issue is very simple. There is a presumably intentional statutory distinction between freezing, where the State Energy Coordinator, in consultation with the Commission, may freeze, and lifting the freeze, where the freeze, when the calculation meets the requirement, shall be lifted. That is the basis of staff's argument on this position. Mr. Myers has very eloquently offered a large amount of legislative history on this subject, which in staff's view does not help to clarify the subject. And I'd be more than willing to go into that discussion, could push versus can push, and how the cap operates if the Commission has any further questions. But essentially, that distinction is the basis of staff's argument for discretion in this matter. The next argument, stemming from DENREC's reply comments to the July 25 regulations, is who has discretion. Now, DENREC contested that the July 25 regulations did not comport with the Administrative Procedures Act, and they also contested that, quote, the Commission's regulatory authority is limited to specific topics, end quote. However, staff finds this contention persuasive, that the Commission is a creature created by statute and its jurisdiction is limited to where the General Assembly provides jurisdiction. However, over RPS compliance, it is the Commission with the exclusive jurisdiction over RPS compliance and not the E&C Director. So even though staff finds DENREC's position and contention persuasive in that regard, staff would posit that that same contention should apply to the E&C Director, where when interpreting this statute, the Commission should look to where its exclusive jurisdiction lies and where the E&C Director's jurisdiction lies. If the Commission decides to grant sole discretion to the E&C Director, there's an additional situation that the commission should be made aware of before it decides to take that path. So staff and other commenters are in agreement that for nothing to happen really isn't an option. Once the calculations are performed, there should be some final agency action on the matter. I quote Gary Myers as pointing this to not allowing a quote-unquote silent freeze, a silent avoidance of a freeze, where if the percentages are over the threshold, something must happen. So stemming off of that contention, if the commission provides the exclusive discretion to the E&C director, Delmarva only listens to the commission. And if the exclusive discretion is with the E&C director, the commission may be forced to defend an order based on the determination of the E&C director that it does not agree with in court, which in my perspective is an extremely untenable position for the commission to be in. It seems to me that as a result of your jurisdiction over RPS compliance and your position as having jurisdiction over Delmarva Power, it seems that the commission is in a great position to review and determine after the consultation whether a freeze should be initiated. So that was kind of my crash course through all three issues. Hopefully I made it in under 15 minutes. I'd be more than happy to answer any questions. No, we'll let it go. So thank you, Chair and Commissioners, and I'm very interested to hear what my fellow interveners have to say.
Thank you, Mr. Deleuze. Ms. Iori?
Thank you, Chair Winslow and Commissioners. And Chair, I do appreciate extending our time to 15 minutes. Hopefully, I won't talk too fast for Gloria. Staff's arguments are facially appealing, but as we will demonstrate, they're all wrong. Staff has cited little to no authority for any of its legal arguments. Instead, it hangs its hat on one sentence from Judge LaGrove's opinion, pulled out of context. There are other statutory construction tenets that staff has not identified for you. Now, before the meeting, I handed out a handout of it's a PowerPoint I managed to do by myself, which is amazing in and of itself, because everybody knows how computer illiterate I am. But I thought that it would be helpful to have a visual while I talked. So here are the statutory interpretation tenets that we set forth in our written comments. And the first one is that the goal of any statutory interpretation is to effect the legislature's intent. And there are others. Can't depart from the clear meaning of a statute, read words and phrases within their context. If a statute defines a term, then that definition controls. Importantly, statutes must be viewed as a whole in a way that gives effect to all of its provisions and avoids absurd results, and to avoid literal or perceived interpretations that yield, quote, mischievous or absurd results, end quote. Finally, you want to avoid surplusage in construing the statutes. Every phrase should be given meaning and possible. So in deciding what regulations you'll approve today, you'll be interpreting several sections of the Renewable Energy Portfolio Standards Act, or REPSA. And I know that these arguments are pretty technical. I know when I talk about this to people, I geek out about it, but I see their eyes glaze over and they look desperately to try to see if there's somebody else to talk to. So, as I said, hopefully to make it easier, this handout distills the 70-plus pages of comments that the DPA submitted into smaller chunks. But make no mistake about it, your decision today will have a significant financial impact on Delmarva ratepayers. If you agree with the DPA, Mr. Myers, and the Cesar Rodney Institute's interpretation of the pertinent REPSA sections, which is the same interpretation that your own staff accepted until this docket was reopened, you'll conclude that the amount that Delmarva pays for Bloom Energy output that the legislature has specifically authorized it to use to fulfill its REPSA requirements should be included in the cost of REPSA compliance. That is, for purposes of determining what the compliance costs are for sections 354I and J, the cost of the Bloom output is just like the cost of RECs and SRECs. That is the trade-off that the General Assembly gave Delmarva ratepayers in exchange for saddling them, and only them, with the entire cost of an economic development plan that was supposed to benefit all Delawareans. And if the Bloom costs that Delmarva uses to fulfill its REPSA requirements are included in the cost of compliance, the cost of compliance will exceed the total retail cost of electricity for retail electricity suppliers by almost 9%, far more than the 3% statutory threshold. If you agree with your staff's current interpretation of the pertinent statutes, however, you won't include the Bloom costs in the cost of REPSA compliance, and you'll be denying ratepayers the one benefit that the General Assembly intended they get from shouldering all of the entire Bloom investment. So to the handout. Page 2 is the language of REPSA sections 354I and J. And I put the important words in this, or phrases in this statute, in different colored ink, so because I wanted you to focus on them. Now, the definition in the proposed regulations ignores the phrase "for retail electricity suppliers," but this commission cannot ignore that mandatory provision. And why is this important? Because as you've heard from Mr. DeLosa, staff's definition makes the total retail cost of electricity the total cost to end-use customers, which includes transmission, distribution, and delivery. If you go to the next page, these are the operative definitions of retail electricity suppliers and end-use customers. The definition of retail electricity supplier means, quote, a person or entity that sells electrical energy to end-use customers in Delaware, including but not limited to non-regulated power producers, electric utility distribution companies supplying standard offer, default service, or any other successor service to end-use customers. And an end-use customer means a person or entity that purchases electrical energy at retail prices from a retail electricity supplier or a municipal utility. If you go to the next page, we take a little detour to explore the difference between means and includes when those terms are used in a statute, and they are not synonymous. Means means that there is no meaning other than what the term states. It is exhaustive. REPS's definition of both retail electricity supplier and end-use customer use the word means. So a retail electricity supplier is limited to a person or entity that sells electrical energy to an end-use customer. And an end-use customer is limited to a person or entity that purchases electrical energy from a retail electricity supplier or municipal utility. A retail electricity supplier does not include a person or entity that sells delivery service to an end-use customer, which makes sense because Delmarva is the only retail electricity supplier that also provides delivery service to customers. Third-party suppliers don't deliver electrical energy to their customers because Delmarva has a state-granted monopoly on delivery service. And end-use customers don't include a customer that purchases delivery of the electrical energy that he purchases from a retail electricity supplier. So staff's proposed definition, which states that the total retail cost of electricity is the cost of electricity plus transmission, plus distribution, plus delivery, is wrong as a matter of law. So what does go into the total retail cost of electricity for retail electricity suppliers? Well, obviously, the cost of the supply. And for Delmarva, that's what it pays for the SOS that it gets through the auctions. The total retail cost of electricity for retail electricity suppliers also includes a profit margin. And for Delmarva, that profit margin is the RARM. And the total retail cost of electricity for retail electricity suppliers includes any other costs that the suppliers include in their final retail price charged to customers, transmission, taxes, whatever. Now, we don't believe that transmission charges should be included in the cost, but because currently retail electricity suppliers other than Delmarva do include it in their retail price, in order to be logically consistent, we have to include it too. If you go to the next page, this is a screenshot. It's page, sorry, I can't see, 7, is a screenshot of Constellation's website showing its price per kWh. And it's offering 8.49 cents or 8.79 cents for a 12-month fixed rate. Those rates include the cost of supply, the cost of transmission, the profit margin, and whatever else Constellation includes for the price of the electricity, of the electrical energy that it sells to end-use customers. The next page shows Delmarva's price to compare. And as of August 2017, Delmarva's per kWh price was 8.46 cents. That 8.46 cents includes the cost of SOS, the RARM, and whatever else Delmarva puts in there. So that is the total retail cost of electricity for retail electricity suppliers. The per kWh price at which retail electricity suppliers sell electrical energy to end-use customers. On the next page, there are several problems with staff's proposed definition of total retail cost of electricity. We discussed them at length in our comments, so I'll just hit the high points here. First, it ignores the deregulation of the supply and generation function that happened in 1999. When it deregulated the supply generation function, the legislature created a product, electricity, that exists without being delivered to a point of sale. And the Restructuring Act specifically requires Delmarva to separate prices or rates for supply, transmission, distribution, and other services. And as noted previously, there is no competitive market for delivery service. Only Delmarva can provide that service. Now, the next 2 pages are part of a bill, this is pages 11 and 12, are part of a bill for a customer that obtains its supply from Constellation. And you can see that the charges for electricity supplied are separate from the charges for delivering that electricity. Going to page 13, the proposed regulations definition renders the phrase, quote, for retail electricity suppliers, end quote, surplusage. If the total retail cost of energy was the total cost to the end-use customer, that phrase would not have been necessary. The fact that the legislature put it in there means that it has some meaning and it can't be blithely ignored. Going to the next page, staff's proposed definition collapses the distinction that the legislature made between retail electricity suppliers and end-use customers. It ignores the distinction that the legislature made between the cost of electricity as a commodity that can be sold by itself to end users and the cost of how that electricity gets to end users. Going to page 14?
15.
I'm sorry, 15. Staff says that the different language in section 363 proves that the legislature meant the total retail price of electricity for end-use customers, but it does not. That section only applies to electric cooperatives and municipal electricity suppliers. Indeed, the title of that section is, quote, special provisions for municipal electric companies and rural electric companies. So because the legislature created special provisions for those entities, it makes sense that it's not the same thing for Delmarva or other retail electricity suppliers. Going to the next page. Staff's proposed definition results in charging end-use customers twice for distribution and delivery costs, once in their bills that they pay, and again because those costs are included in staff's calculation of the total retail cost of electricity. So when the statutes are read together, as they must be, it's clear that what the legislature intended to be measured is the total retail cost of electricity for retail electricity suppliers, which is the retail price that retail electricity suppliers charge their customers for the electricity that they sell. Now, on the next page, we don't believe the statute is ambiguous, but let's assume for a moment that it is. if you look at all of REPSA, it confirms that it's all about renewable energy supply, not delivery. On page 17, we identify various sections of REPSA that demonstrate this point. So, going to the next page, to recap, whose interpretation gives effect to all of the statutory language? Not staff's, because that interpretation writes the phrase "for retail electricity suppliers" completely out of sections 354I and J. It's the DPA's, and our proposed definition should be approved. Moving on, the next page, to what is the most important disagreement that the DPA has with the proposed regulations. And you see there a picture of the Bloom facility. Whether the cost that Delmarva ratepayers pay for the Bloom energy output that Delmarva is statutorily authorized to use to fulfill its REPSA requirements should be included in determining the total cost of compliance for purposes of determining whether the Section 354 cost caps have been exceeded. Pages 20 through 22 set forth the pertinent statutes. Page 23 sets forth the same statutory interpretation tenets that I identified earlier. Just looking at them again. Page 24. The first question is whether Section 354's identification of compliance costs is exhaustive, or whether there can be other compliance costs that aren't specifically identified. Going to the next page, we are back to the difference between needs and includes. Remember that means admits of no extension. What's there is it. But includes is different. It is partial. It allows an administrative agency to add items that are not specifically identified as compliance costs. Section 354I and J both state that the total cost of compliance, quote, shall include, end quote. So the total costs of compliance are not limited to only the things specifically identified there. Now, Mr. DeLosa argues to you that the phrase should have, if they really meant to not allow anything else, they should have said includes but is not limited to. But as former Justice Antonin Scalia says in his treatise on legislative drafting, that phrase is a belt and suspenders that is unnecessary and, in his view, just confuses things. So, again, the total costs of compliance are not limited to only the things specifically identified there, and the Commission can include the Bloom costs as a cost of compliance with REPSA. It is clear that the General Assembly intended the Bloom output cost to be the equivalent of RECs or SRECs. Going to the next page. Section 353 D1 A.1 and A.2 allow Delmarva to use more of the Bloom output to fulfill REPSA requirements if it would otherwise incur a solar alternative compliance payment, or if the General Assembly increases the SREC requirements in Section 354A. Both alternative compliance payments and SRECs are costs of compliance that are specifically identified in 354I and J. The Bloom output is the same thing as an SREC for purposes of REPSA compliance. Next page. Staff contends that Section 364D says that allowing Delmarva to use the Bloom output reduces Delmarva's REPSA requirements. It does not. Staff isolates the language of Section 364D and does not read it in connection with Section 353D. But Section 364D specifically refers back to Section 353D and must be read in connection
Ms.
with...
Iwer,
Yeah.
you may find this hard to believe, but you've already exceeded 15 minutes. Could you wrap it up?
I have? I'm sorry. All right. Well, we note in our comments that the Commission has already recognized that Delmarva uses Bloom output to fulfill REPSA requirements. Every order since the Bloom tariff went into effect has contained language recognizing that. We also note that it wasn't until this docket was reopened that staff changed its opinion on whether Bloom costs were included. When this was pending before DENREC, their position was that Bloom costs should be included as a REPSA compliance cost. Staff's recommended interpretation eviscerates the General Assembly's intent and leads to an absurd result, and it should be rejected. I just want to point out one thing that was not in staff's previous memos, but was in this one. Staff argues that there are significant negative costs in the form of environmental and other benefits as a result of REPSA compliance, and shouldn't those also be included in the cost of compliance if Bloom is? Well, no, they shouldn't. It ignores the fact that nothing in REPSA allows consideration of those alleged benefits, whereas REPSA specifically contains provisions making the Bloom output the equivalent of RECs and SRECs. The difference is that all of the items in 354I and J are items whose value can be precisely calculated. We know how much purchase prices of RECs and SRECs are to the very cent. We know what alternative compliance payments are to the very cent. And we know how much is spent on ratepayer-funded renewable energy rebate programs to the very cent. They're all discrete amounts. Externalities are not. I thank you for letting me go over a little bit. Thank you for your attention.
Thank you, Ms. Ivory.
But I do want to point out, there are ducks in this. If you look at the very end, Mr. Delosa said you might hear something about ducks, and there are ducks.
Mr. Myers?
Hi, for the record, my name is Gary Myers. I'm one of the commenters here. I happen to be a DPNL customer, so I guess I have some sort of standing. I was somewhat prepared to go through each of the three issues and offer some rebuttal to Mr. Delosa's remarks, sort of summarizing what I put in my rebuttal comments. But something the chairman said struck me, and I think I'll try to talk to that more. Everybody sitting around, at least this end of the circle, I think would agree that the two cost cap provisions are a real mess. Staff has correctly identified the three issues that everybody's argued about for the last 6 years. When DENREC was in charge of the ball game, they changed their position on these three issues 3, maybe 4 times. When staff has had it, your staff has changed its position on all three issues almost one time already. So it's a real mess. And you can turn and say, well, why is it a mess? Well, part of it is Senator, well, no, I won't mention names. The legislature could have chosen some better language when it wrote the cost cap provisions and maybe cleared up some of the, I don't want to say ambiguity, because I don't think it's an ambiguity, but some of the premises for an argument. But there's a bigger reason why this is a mess. And that's it because the world didn't turn out the way the folks in 2010, when they put the cost cap provisions in, thought it would. When these cost cap provisions were put in, everybody thought wholesale electric prices were going up. Well, guess what? Natural gas and wholesale electric prices have ended up going down. So what's that mean for the cost cap provisions? Well, that means that the bottom part of the formula, what's the total cost of retail cost of electricity, which necessarily includes wholesale cost of electricity, that number is much lower because the prices for electricity is much lower. What does that mean? That the cost of compliance for renewables is more than likely going to exceed the thresholds. So that's one of the problems. The second problem that everybody recognizes is, a year after they enacted the cost caps, Delaware signed on to the Bloom Energy subsidy. Now, they tried to give value to what Delmarva's customers were going to pay by, in effect, saying these are going to be RECs. They'll avoid the REC cost that you'll have to pay and so forth. But then what happened? Well, the Bloom Energy cost went beyond anybody's expectations. So the thing is a mess. It's been 6 years. It's a mess. We've been arguing about it for DENREC for 4 years, a year here. Nobody's gone back to the legislature. I don't know why, but nobody has. It's got to be fixed. And in a way, The real problem is, in a democracy, the people that fix it is the General Assembly, not you or not the courts. So how do we get this thing back in front of the General Assembly? How can we do what the commissioner is pleading someone to do? Well, I think is an out. And you've been offered two options today. One is adopt staff's proposal, the rules that are proposed now, the rules that are the same that Denrick proposed. Well, what's that gonna do? Nothing. How come? Well, 2 years ago, when Denrick had the rules, the cost caps, both of them, were breached. Denrick decided, exercising its discretion, that there shouldn't be a freeze. Last year, Denrick found the cost caps breached. What did they decide? They weren't gonna freeze it again. So if you let this go on, unless some miracle happens, or there's some drastic change in electricity cost, that's gonna be the yearly scenario. Cost cap numbers will be breached. We'll be spending more on renewables than the legislature set out, the 3% and the 1%. Denrick will come to you and say, boy, renewables are just too important. We're not gonna freeze. You're gonna be put in the position of saying, under Mr. Delos's approach, you're gonna be put in the position of saying yay or nay to that. The pressure's gonna be to say nay, and it'll go on. And it'll go on and on and on. And the real problem is, nobody will know what's too high. When do we get to that point where what consumers pay is way above the 3% is just too high? You'll never know, and guess what? The cost cap will just fade away. If every year you're gonna say, the numbers are breached, we'll continue on, the cost cap means nothing. And it was an important part of the legislation. It's how this legislation was sold. Because back in 2010, what Secretary O'Meara told everybody and Senator McDowell what they said was, we're gonna accelerate the amount of renewables you have to have. And people went, whoa, what's that gonna cost us? And their response was, don't worry about it. You don't have to worry about that because we're putting something new into this legislation, and that's a cost cap. So you'll never have to worry about going over 1 or 3% of what electric prices are. You'll never have to worry. It'll just shut down when that happens. It'll circuit break out, as they told the legislature. Well, if you do nothing, that circuit breaker's gone. What Denrick and everybody and staff in a way is suggesting is not a circuit breaker, it's that little penny you used to put in fuses. And the thing runs on and you're hoping the penny doesn't blow up. So if you adopt your own thing, it won't get fixed. It needs to be fixed. Somebody has to say, whoa, gee whiz, under lower electric prices, these cap levels are way too low. We won't have renewables if these cap levels apply. The legislatures do that. We can argue about that in the General Assembly. Or we can say, well, blooms turned out to be a bad deal, but they were always subject to the cap. And the legislature can tell you that, rather than fighting about it for 4 or 5 more years in court. So if you adopt your rules, this won't get fixed. What's the other option being offered to you? Our option. And I can guarantee you, if you adopt our option, there'll be a bill in the legislature in the next session. Why? Because we'll shut the place down next September. Because under our thing, which we think is just what the statute said, under our thing, there'll be a freeze next year. The cap numbers are surely going to be breached. They were breached 2 years ago, maybe breached 3 years ago, they'll be breached last year, they're going to be breached this year. And they'll be breached by a couple percentage points. It's not, we're spending $32 million on half of the thing. So if you adopt our proposal, everybody's going to know that come the reporting period at the end of next year, there's going to be a freeze. And Denrick can't do anything about it. Because under our proposal, or at least mine, I don't know about theirs, it's automatic. It's the circuit breaker Secretary O'Meara and Senator McDowell told the legislatures this bill would do. Its circuit breaks out, the place is suspended. So, that's the way to get it back from the legislature, because DENREC, their allies will in effect say, this has gotta be fixed, and it does. And they'll be running to the legislature to change that. That's the way to get this thing resolved. Now, you could say, well, that's too Machiavellian. We're not talking about may or include or, you know, whether there's a comma here or a comma there. But what this is all about is a promise made to consumers in 2010 by the legislature. But what they said was, bear with us when we raise the renewables, a good thing, because you're protected. Because you're protected by these cost caps. If in effect you adopt these rules, you break that promise. The promise, you take one half of it off. The renewable percentages were up and accelerated, but the cost cap is gone because DENREC will always waive it. Or, I don't know what the right word is. They'll forego it. And we'll go on forever. That can't be what the legislature intended. So my point is, if you want to fix something, here's the way to do it. If you don't want to fix it and have 6 more years and a yearly argument about is the cost overruns too much compared to benefits, then you've just done away with the cost cap. It won't be 3 or 1%, it will be how do we figure out cost, how do we figure out benefits, what's too high? That's not what the legislature was doing. They wanted simple numbers. They put them in there. Why put the numbers in if you're going to do this yearly calculation or there's some discretion about costs and benefits on either side? So that's my pitch. It's not a lawyerly pitch, but it's a way of getting things done. Now, I love analogies. How many more minutes do I have?
None.
About 4 or 5 minutes.
Okay. Because she's done a great job, but I want to speak to the discretion issue and the word may. We get a drink. Everybody says may means discretion. Yeah, sometimes it does. Sometimes, and particularly in legal documents and statutes, it doesn't. Particularly when you're saying, this officer may relieve you of some obligation. In that sense, you don't expect it to say, well, the officer can make up his mind whether he's going to give you an out or not. You usually say, well, if you fill the criteria, he's got to do his work. He's got to relieve you of the obligation. And that's what's going on here. It says you may go over the threshold. He may lift the obligation on Delmarva or the suppliers beforehand to, in effect, continue in the program for that year. So that's why may's in there. And here's my analogy. I love this one. Let's say your kid's on an 8-year-old Little League team. And the Little League, for 8 years old, has a slaughter rule. I don't know if you're familiar with slaughter rules or not. But the slaughter rule, written out in the book, you know, the little book they give you in Little League, and it says, if at the end of the 5th inning, one team's up by 10 runs, the umpire may call the game at that point and end it. Uses the word may. Okay, there you are, you know, April, late or 3rd week in May, you're playing the league champion, your team's down by 20 runs, end of the 5th. So you sort of saddle up to the umpire and say, do you remember the slaughter rule? And he looks at you and he says, yep, I know the slaughter rule, and it says may. I'm not going to end this game because I think this championship team needs more times at bat to practice for the upcoming championships. Well, who would ever think that the word may gives him that kind of discretion? It says if you're up by 20, I mean, if you're losing by more than 10, end the game, ump. It doesn't say, well, you figure it out whether we're going to end this game or not. It was meant, the slaughter rule was meant to protect from embarrassing the kids. It was an option given to an officer to protect the kids. Same deal here. The director was given the option of ending a legal requirement if he made the determination that it was over the cost caps. And it was perfectly permissible, perfectly grammatically correct to say may in that situation. Mr. Delos will say, but they said shall later on, so they must know what may is one point and shall is the other. It's different. Well, but that doesn't make sense here. Because the first one is a power to avoid obligation. The second one, when it says shall, is a command. If your expected costs are under the cap, you gotta put it back in. But that doesn't make the first one permissive or discretionary. It just realizes that in the first instance, you're giving him the power to relieve a legal obligation. The second one is a command to resume it. They both say must. And you can walk away from any discretion. So thank you.
Thank you, Mr. Myers. Let's see here, Mr. Stevenson, we'll just go right down the line.
Okay. David Stevenson. What they said. With two exceptions.
Thank you very much. Scott.
With two exceptions, I've never walked away from a conversation with Ms. Iori, and I was an intervener in the fuel cell docket in 2011, and I got the estimates right. I said it was gonna cost $432 a month, it's actually at $455. So, I wanna talk about that. Don't you love lawyers? You guys now have a legal basis to do anything you want, including outlawing Mondays. Probably a good thing. So, you are going to do what I hope, what you think is right, just and reasonable. You use that term all the time. So, going back to 2011, when the Fuel Cell Act was approved, there was a cap of how much it could cost. And that was based on the highest tariff available, which at the time was Blue Water Wind. And the PSC consultant said that that had a value of $2.42. So if it was gonna cost more than that per month, commissioners would have had to vote no. Well, the actual calculation was $3.30. But they got to deduct the value of what the consultant said was those renewable compliance charges that were going to be given to the customer, which was about $2 a month. So it came down to $1.34. It was under the $2.42. So, we had 550 public comments for that docket, and all except 2 were against the fuel cell docket. Customers did not want that, but they wound up with it. And they have a reasonable expectation that the one benefit they were supposed to get is the value of those renewable energy credits. Secondly, we went through docket 13250. I was also an intervener. That was the transparency docket where we put the wind and solar cost and the fuel cell cost on the electric bill as renewable compliance charges. Once again, the customers look at their monthly bill and it says renewable compliance charge, and here's Bloom, and it's so many dollars a month, over $5 at this point. And the customers have a reasonable expectation that they're paying a renewable compliance charge, which ought to be going against the cost cap. So there was one other argument that I saw that I don't know if it's still in there or not, but the staff said, well, Delmarva doesn't pay an actual dollar amount for these RECs, for the fuel cell RECs. But in fact, what if they built their own solar farm? They wouldn't be paying a dollar amount for the SRECs they got from that solar farm if it was owned by Delmarva, just like the Delaware Electric Co-op actually is doing. So I would set that aside. So it seems to me Oh, and by the way, Delmarva came out with the 2016-17 compliance costs, and they're paying $25 for actual wind wrecks. And if you do the calculation, they're paying $78 for the fuel cell wrecks. And that's even getting 2 for 1. So it's costing ratepayers a lot of money. So my advice would be, take whatever legal argument you need so you don't get sued, and include the fuel cell cost. And I agree with Mr. Myers, it's time for the legislature to take a look at this, and freezing the RPS will get their attention, and we'll get this solved once and for all. Thank you.
Thank you, Mr. Stevenson. Ms. Scott?
Good afternoon, Chair Winslow, members of the commission. My name is Deborah Scott, and I'm a Deputy Attorney General, and I represent DENREC. And with me today from DENREC, Division of Energy and Climate, is Tom Noyes. I just want to say from the outset that I agree with Mr. Myers when he said that if the statute needs to be fixed, the General Assembly must do it. But if there are problems with the statute, it's not the burden of this commission to take away DENREC's discretion in order to force the General Assembly to act by imposing a freeze. It's a policy decision and it's the General Assembly's job to correct any problems that there may be with the statute. Today, DENREC's offering comments on 3 issues, and I will address the issue of DENREC's discretion to declare a freeze on the Renewable Portfolio Standards, the RPS, and Mr. Noyes will address the definitions of total retail cost of electricity, and he'll also address the issue of whether qualified fuel cell provider costs should be included in the calculation of the total cost of compliance. On August 1st, 2017, an amended version of the regulations were published in the Register of Regulations, and those regulations were amended again, and that is the version that is before the Commission today. The staff in its memo stated that these changes are not substantive, and DENREC disagrees. The staff states these changes, the amended regulations contain substantive changes to both versions of the regulations, which require the Commission to publish them again according to the APA, Section 10115A. The August version of the regulations contained provisions that would subject DENREC's discretion to judicial review under the APA when DENREC is clearly exempted from the APA's provision for case decisions. DENREC disputed that provision and it was removed from the current version. The latest version, however, eviscerates DENREC's statutory authority and discretion to freeze the cost cap and gives that authority to the Commission. Under this version, the Commission can affirm, deny, or amend DENREC's decision to freeze the cost cap. This change turns the statute on its head by swapping the Commission's consultation role and DENREC's decision-making role. This is a substantive change, and the draft regulations conflict with the statutory language, and therefore they illegally preempt the statute. The language of the statute is clear, and Ms. Ivory has given you a lot of information about statutory interpretation, but when a statute is clear and unambiguous, a court will have to give meaning to that language. DENREC has the discretion to freeze the cost cap in consultation with the Commission if its calculation of the cost of compliance exceeds 1% and 3% of the total cost of electricity for retail electricity suppliers during the same compliance year. Nowhere in the statute does the Commission have the power to approve, deny, or modify DENREC's decision. The Commission's role is to consult, not to confirm. And that is the way the General Assembly drafted that statute, and it's up to the General Assembly to amend this language if that is not what it intended. Giving the Commission a role that's more than one as a consultant conflicts with the statute. And there's been a lot of discussion in the comments about the meaning of may and shall. DENREC's position is that the statute is clear, that the director has the discretion and may freeze the cost cap if the calculations are required to do so. There have been arguments about the meaning of may and shall. Ordinarily, courts interpret may to have a discretionary or permissive meaning, and shall imposes a mandatory duty. If that meaning is in dispute, which again, we think that the language is plain and clear, then the test of the meaning is contextual. Therefore, the meaning should only be considered in context with the setting of the statute and should only be changed to a mandatory duty if the statute suggests a different interpretation. And that is from a Delaware Supreme Court case that Mr. Meyer cited as well, Miller v. Spicer. Here, when the term is viewed in context with the statute, DNREC maintains its discretion, and the statute is instructive. In the same section of 354I and J, the General Assembly uses both terms, may and shall. It gives DNREC the discretion to impose a freeze, but it also requires DNREC to lift a freeze if the total cost of compliance dips below the 1 or 3% thresholds. A court construing the plain language of the statute will find that the statute is clear and unambiguous, and if the General Assembly intended the freeze to be a mandatory task, it would have used the term shall. A court would compare the statutory language that addresses DNREC's authority to make a finding to lift a freeze. And in that language, it says the freeze shall be lifted. I think as some of the other commenters have cited to that language as well. In addition, the stated policy of REPSA is that renewable energy is a benefit to the public at large, and that developing renewable energy resources is an obligation of both electric suppliers and consumers. It's not purely an economic issue. The purpose of this, the stated purpose of the statute is to improve air quality, improve public health, increase electric supply diversity, increase protection against price volatility and disruption, improve transmission and distribution performance, and to provide new economic development opportunities. And just in rebuttal to the staff's memo, in which they want to create a right to judicial review of a final agency action by opening a docket on a cost cap determination. And this change was done in response to DNREC's arguments that the APA does not provide judicial review for a case determination by DNREC, and that is what the plain language of that statute states. So in order to circumvent that argument, staff wants to create a right to judicial review by having the commission open a docket on a cost cap determination. And it cites the commission's authority to monitor and verify the RPS compliance in support of that argument. But that authority only extends to the commission's authority over commission-related electric companies, not over another state agency such as DNREC. Staff argues that the commission can't issue an order without any deliberation. And I think they concede that the changes to these regulations would allow the commission to overturn or modify the DNREC's, the director's determination whether to institute a freeze. But there's no statutory requirement for an order for the commission to issue an order related to its role as consultant. If DNREC determines that a freeze should be imposed, then the commission's authority over the commission-regulated electric companies is then triggered. At that point, it would be appropriate for the commission to issue an order instructing the CRECs that the RPS has been frozen. DNREC understands that implementing the statute has not been an easy task, but the statutory language that addresses the roles of DNREC and the commission in relation to freezing the RPS is clear. DNREC has the discretion to impose a freeze in consultation with the commission. If DNREC declares a freeze, then the commission has the authority to implement that freeze with the commission-related electric companies. The commission does not have the authority to approve, deny, or modify the freeze determination made by another state agency, DNREC. And now I'm going to turn our comments over to Mr. Noyes.
Thank you. And I will be brief. On this declared plain language day, We respectfully suggest that a narrow focus on statutory language is more likely to get us to a regulation that is workable and consistent with the statute than some of the other approaches that we've heard here this afternoon. Turning to the total retail cost of electricity, we concur with staff. The argument that the phrase total retail cost of electricity should be interpreted to mean wholesale supply costs is not consistent with the meaning of the word retail. DPL is not a retail customer. It buys electricity in wholesale markets. The phrase total retail cost of electricity properly includes all the costs on customer bills. Electricity is not a retail product until and unless it is delivered to customers. It's not physically possible to buy electricity as a retail customer in a wholesale market without using the company's transmission and distribution assets. The difference in the REPSA sections concerning municipal companies and rural electric cooperatives has been pointed out, and we agree with staff's point of view on that. The DPA's argument that staff language would result in charging customers twice for the same cost has left me scratching my head. Unless I'm missing something, the DPA has not connected the dots here. There's no plausible mechanism between calculating the costs for the purpose of the cost cap and imposing some cost on customers twice. Perhaps I misunderstood the argument, or maybe the argument is hard to understand. In summary, we agree with staff's position on the total retail cost of electricity. Turning to Bloom, staff properly sticks to the statutory language in crafting language identifying the component cost of compliance with the RPS, which staff has identified. There are 4 reasons based on the statute for not including Bloom or QFCP, Qualified Fuel Cell Provider costs, in the cost of compliance. 1, the statutory text does not include Bloom in the enumerated cost. That point has already been discussed. 2, Bloom is not an eligible energy resource. It's not defined in REPSA as renewable energy. 3, Bloom does not generate renewable energy credits or RECs. And 4, DNREC does not have the authority to freeze Bloom, and neither does the Commission. To elaborate slightly, the General Assembly, as is pointed out, could have expanded the definition of eligible energy resource to QFCP output, but did not do so. Instead, REPSA was narrowly amended to allow one utility to offset a portion of its RPS requirement with a particular source to a limited degree based on specific requirements and with the approval of the PSC. As for generating RECs, Bloom does not generate RECs. RECs are defined as a tradable instrument equivalent to 1 megawatt hour of retail electricity sales that is derived from eligible energy resources. Bloom is not an eligible energy resources. This point is so problematic that the DPA proposed to amend the regulation to change the definition of RECs and SRECs to include Bloom in order to fulfill the intent of the General Assembly. We don't think it's appropriate here to change the definition in the regulation to expand it beyond the definition in the statute. Finally, DNREC does not have statutory authority to freeze Bloom costs, and neither does the PSC. So even if the Commission wanted to include Bloom in the cost cap, where the General Assembly did not, DNREC would be put in the position of measuring apples to possibly freeze oranges. And let me make that clear for those who are here primarily out of interest in Bloom. We could be put in the position of measuring Bloom and freezing renewable energy. This is not about protecting ratepayers from Bloom costs. We, for good or ill, do not have the authority to do that. In summary, on the question of Bloom, the statutory language does not define Bloom as renewable energy, does not provide for Bloom to generate RECs, does not include Bloom in the calculation, and does not give DENREC or the PSC the authority to freeze Bloom. Clearly, the Commission has some contentious issues on its hands. In arguing these issues, we again are grateful to be doing it on Plain Language Day. And we urge the Commission to be mindful of the statutory language itself and the other mandates, the judge's opinion, and the Commission's own orders reopening this docket for the limited purpose of complying with the judge's orders. We thank you for taking the time to listen to our arguments. Anything else? Thank you, Commissioners.
Thank you, Ms. Scott, Mr. Noyes. Is there anybody here from the general public that wishes to make any comments to the Public Service Commission on this matter? No one is approaching the table, so I assume that there isn't. Now, I believe that Ms. Iori unintentionally and probably by just a mistake went past her 15 minutes of time. And I think it would be appropriate to give this to staff about 3 or 4 minutes to add something in rebuttal, given the fact that they had a pretty good amount of time.
If I'd known that, I would have just shut up.
Mr. Myers?
Why don't you give everybody 2?
We would rather forego our 4 than give everyone 2.
Come on now.
Okay, Mr. DeLosa, you've got 3 minutes.
Thank you, Chairman. Chairman and Commissioners, I'd just like to offer a little bit of rebuttal on what you may have read in some of the comments, a little bit more than what has been discussed today. With respect to the total retail cost of electricity, Mr. Myers offers in his reply comments an analogy, as he's so adept at doing, the retail cost of a car wheel from an auto parts store, right? And what Mr. Myers posits in that example is that if I go with a busted front tire to an auto parts store and I buy a tire, right? Under his assertion, that tire and just the tire, not the cost to get it mounted, would be the total retail cost of the tire for the auto parts store. I'd just like to point out one fallacy in that argument. And that is, there's a lot of different things you can do with the tire. You can make a tire swing, you can put it in the ground as a base for your campfire. Whatever you'd like to do, you can buy a tire, take it with you, and leave. In electricity, that is not the case, right? You can't go anywhere and buy a bag of electrons. You can't put electricity in your pocket. There's only one way that you can use electricity, and that's when you turn on a light switch or plug something in to the grid, right? There is no retail sale of electricity without the distribution grid. Now, moving along that, Delmarva, in its role as a distribution company, is defined as a retail electricity supplier. Furthermore, in the DPA's proposed revisions, while they accuse us of engrafting end-use customers onto the definition, the DPA similarly engrafts the term retail electricity products and decides that that is the correct defined term in REPSA to use to define the total retail cost of electricity. However, retail electricity products are not all that is sold by retail electricity suppliers. And this is made plain as a result of the fact that Delmarva, as a distribution company, is in the definition of retail electricity suppliers. I'll leave it there. Thank you.
90 seconds, Mr. Myers.
Pardon me?
90 seconds.
Okay. 2 things. No, I don't worry about that. One is, did you hear what DENREC said? They want absolute discretion of whether to impose a freeze or not. They don't want a court to look at it. They don't want you to look at it. They don't want anybody to look at it. We know where that's going. The cost cap's going away. They'll always waive. They'll always exercise their discretion to say, you heard him say it, renewables, are priceless. So I had a cost cap from the beginning. My second argument is about the bloom, another analogy. We always require a turkey at my house for Thanksgiving. Giant, has a circular saying you can buy any turkey for $4. Where I rush down there right away and get it. I get up to the self-service thing, you know how you check out. Do all stores have that? I don't know. But you check out, I pick up my wallet and I say, only got 3 $1 bills. What am I gonna do? Well, I'm gonna put 100 pennies in. Well, is a penny $1? No. But 100 pennies, the code in that machine will say, is the equivalent of $1. It's equal, it's equivalent. Everybody will say 100 pennies is $1. It quacks, it quacks. Thank you.
Thank you, Mr. Myers. I would say that DENREC has been totally consistent over the years.
Pardon me?
I would say that DENREC has been totally consistent over the years.
Oh.
Commissioners,
They actually have.
well, except for
No matter
the
what
three times they
percentage
changed
is,
their minds and
there's
one
no
time.
freeze.
Commissioners, questions? Commissioner Gray.
Of course. Thank you, Mr. Chair. Thanks, everyone, for your descriptions and definitions. And my sense is that a lot of the focus has been on the statutory language and from the top down on this issue and not so much from the bottom up. And I've been trying to contemplate as a ratepayer, okay, so what does this mean to me? So without addressing which entity has the authority or the discretion to order a freeze, I'd like to focus on whether or not to include the QFCP in the cost of total compliance. Let's first assume Bloom does not exist. Would Delmarva then need to purchase RECs and SRECs from elsewhere? Can anyone help me with that?
Yes.
Yes.
Okay,
455,000 this last compliance year.
okay. Would these costs then be accounted for as costs to comply with REPSA?
Yes.
Are any costs of REPSA compliance paid to Bloom by Delmarva? And further, are these costs then billed to customers?
I can try to answer that, and I'll let Gina correct me if she thinks I go wrong. I think we'll agree here. Try to give it a straight ahead answer. Delmarva, as the dispersing agent for Bloom, collects a tariff-defined amount for every megawatt hour from customers. And then the output of the Bloom fuel cell produces REC equivalencies
Pennies.
that that are used to avoid the RPS. There's no direct payment for the renewable attribute.
Let me stop you there and interrupt with this clarifying question.
Yeah.
So if Bloom did not exist and Delmarva was purchasing these RECs from elsewhere, would they be getting more RECs or paying less money to get the RECs from someplace other than from Bloom?
The REC requirement, the total amount of RECs would not change. The total REC requirement would not change. As far as a cheaper price, I think Mr. Stevenson has
They were
provided
actually more.
compelling.
I'm sorry, please again.
That the Bloom Recs were 3 times the cost of Recs on the market.
So it is safe to conclude with that statement that Bloom generates cost, even though Bloom does not generate RECs.
That is an accurate
And
statement.
the cost is borne ultimately by the customer.
That is
ratepayer.
also an accurate
Okay.
statement.
So, again, Bloom does not generate the RECs, but does reduce the REC requirement at a cost to ratepayers. So costs which would otherwise be paid and considered relative to the cost of caps if Bloom did not exist. So why therefore should we not include Bloom as part of the total cost?
That is a question you would have to direct to different parties, as they would, I'm sure, have different answers to that question.
Is that all right?
Well, you know our argument. We believe that the Bloom costs should be included because they are, by statutory authorization, the equivalent of a rec or an SREC.
So it's clear for me that they don't generate a rec, but they generate a cost. And I think that both sides of the ledger should be contemplated as an informed decision is made here.
And it is a cost of compliance because the legislature has specifically authorized Delmarva to use the cost of the Bloom output to satisfy its RPS requirements.
Okay, Mr. Myers?
I hate to pick nits, but I will here. Everybody says that the output from Bloom is not a rec.
Not
Because it
everybody.
doesn't create a rec, because it doesn't meet the statutory formula of a rec as enacted in 2007 or 2005. Mr. Noyes could tell you the date. It's not tradable, for one thing. But I think that misses the point, because in 2011, the legislature spoke, and it said the output is equivalent. Now, equivalent's a pretty strong word. It's equal to a rec. It then turned around 2 paragraphs down, I don't have the paperwork in front of me, or a paragraph down, and it said 1 hour of output is equivalent to 1 rec in meeting the SREC and rec requirements of Delmarva. The whole language is talking about them meeting recs. One paragraph down, when they got into, it talks about how do you get an SREC out of Bloom output. SREC being the solar one. And it says, here's the formula. 1 rec from Bloom, 6 recs from Bloom will give you 1 SREC. So you can take 6 recs, and it says that. It doesn't say rec equivalencies, it says 6 recs equals 1 SREC. So what happened in 2011 is, regardless of what the definition was in 2005, the legislature declared that the output from Bloom creates recs.
Mr. Gregg? Yes, with all due respect, the legislature did not declare that Bloom creates recs. Recs are defined as tradable instruments. Bloom output cannot be traded as recs. They cannot be used by any other distribution utilities to satisfy their RPS requirement. They can't be traded. They're not tracked on PJM GATS, which is the accounting system used to track recs and SRECs. Instead, they're used as an offset, and it has been pointed out, they're used as an offset at a premium above current rec prices. And the definition of recs in 2007 is the definition today. The definition of recs was not changed with the Bloom legislation.
Okay, I completely get that. I guess my perspective at the moment is focused more on the fact that there is some substitution equivalency that has been accepted, such that you reduce the requirement for recs from elsewhere if you get them from Bloom. But my real focus is the fact that regardless whether they generate recs, they generate costs. And I'm simply trying to figure out the transaction flow of how that cost is arriving and where it's going.
Commissioner, if I might. I would just have 2 points of rebuttal. In 2011, when the entire Bloom construct was added, the General Assembly chose to amend 15 different parts of the REPSA to add what everyone would agree is a hulking, for lack of a better word, construct. It is riddled with legal nuance and really difficult jargon. If they just wanted to make Bloom an EER, they could have done so substantially easier to create recs. The second point I'll make is, and the DPA and Gary Myers mentioned staff changing our decision. If you are to open what the list includes to include Bloom, There are numerous other, as DENREC has shown in past rulemaking proceedings, there are numerous avoided costs, negative costs, other considerations that are attendant to RPS compliance. It's not just all costs when you look at the RPS. There are health benefits, there are other benefits that DENREC has evaluated and quantified in their past rulemakings. So to keep it simple, staff in this proposed rule tried to just limit it and leave no further expansion, because when you expand it, where does the commission stop it and why there? Thank you.
Chair Winslow, may I be briefly heard?
Yes, ma'am.
I don't believe that was responsive to the question, but you did get your argument in there. This is what Section 353D says. This is what the General Assembly enacted in 2011 with respect to Bloom. The Commission shall develop procedures for tracking the generation output of qualified fuel cell provider projects, such that energy produced by such projects shall fulfill the Commission-regulated electric companies' state-mandated REC and SREC requirements set forth in Section 354 of this title as follows. Subsection 1, fulfillment of the equivalent of 1 REC for each megawatt hour of energy produced by a qualified fuel cell provider project. Subsection A, the Commission-regulated electric company can use energy output produced by a qualified fuel cell provider project to fulfill a portion of SREC requirements at a ratio of 6 MWH of RECs per 1 MWH of SRECs. The Commission-regulated electric company may utilize a portion of energy output from a qualified fuel cell provider project in any given year to fulfill no more than 30% of the SREC requirements unless, 1, due to lack of SREC availability in the market, the alternative would be to incur alternative compliance payments, or 2, the SREC obligations set forth in Schedule 1 of Section 354 of this title are increased, and then only to the extent necessary to fulfill the increased SREC obligations. That is what the General Assembly did in 2011, and it did not need to amend the definitions of RECs and SRECs. It already specifically took care of it in Section 353D by deeming them the equivalent for purposes of the Renewable Portfolio Standards compliance. Therefore, the amount that Delmarva ratepayers pay for those equivalencies are a cost of compliance.
Okay, I'd like to, at this point, intervene and say to the chair that I don't have any further questions. I don't know if you want commission opinions at this point, Mr. Chair, but I'll yield.
Are there any more questions by a commissioner? Ms. Scott, I do believe it's pretty clear from the record that DENREC's position is that you all have unfettered discretion with respect to the issue of freezing that we're discussing in this docket.
Well, Chair Winslow, the statute is clear that the director may freeze. He or she has the discretion to freeze the cost cap
Well,
in consultation with the commission.
If we interpret it in that fashion, then basically it seems to me that what Mr. Myers says is going to happen, or may happen, and that is that you have the unfettered discretion to not go into a freeze mode and actually talk to the commission about it, or maybe you would have to talk because it's above the threshold. But you could ignore whatever the commission says and continue to exercise your discretion.
Actually, the statute only requires DENREC to consult with the commission if it determines that those thresholds have been reached.
Correct.
If DENREC determines that a freeze is not warranted, it has no obligation or duty to consult with the commission. However, I believe that the draft regulations provide both scenarios now, that DENREC comes before the commission, whether it decides to freeze or not freeze. And that is the way that its discretion is based on statute.
Well, it's based on the interpretation of the statute. You're interpreting it in a way that is perhaps, someone could say is in DENREC's best interest, whereas Mr. Myers would indicate to you that that may is not just as permissive as you would like it to be. Is that fair to say, Mr. Myers?
Oh, yeah.
And certainly, the commission is promulgating regulations that gives DENREC basically the formula to make that calculation. So what the General Assembly intended, whether, originally we argued that we had the discretion as well to determine, what factors go into that total cost of compliance. But at this point, we've conceded that, the commission is going to make that determination. But the statute gives DENREC the discretion to make the freeze determination. Otherwise, I don't know what the purpose of DENREC's role would be at all. To just sit at a calculator and do some math and then turn that over to the commission. If there are clearly a lot of problems with the statute, but that is for the General Assembly to correct and fix. As we read the statute as it is currently written, the director has the discretion to determine whether to freeze.
I think we have the discretion to interpret the statute, and one interpretation has been given to us by Mr. Myers and also by Ms. Iori. And that would, I think, give more weight to the 1% and 3%. In other words, under the scenario put forth by the staff and by DENREC, that 1% and 3%, although a clear legislative intent and purpose, can very well be eviscerated by a continuing waiver of, or ignoring, because of other reasons not set forth in the statute, failing to freeze freeze the rate.
And I understand that this has been a long process, and DENREC had regulations for the first time last year and did its calculation and determined that the total cost of compliance was below those thresholds. So DENREC did, and maybe others will dispute how the calculation was done, but they didn't, in DENREC's, it's DENREC's position that those thresholds were not met, so they did not impose a freeze. I don't know that,
Okay, thank you.
I think you're going to get a lot of dispute that the caps were not breached last year.
Just ask Mr. Green. I've read his report.
Chairman, as a point of information, just so that the commission has some bearings as to what the impact of Bloom would be on the calculation, under staff's proposed rules in 15-16 compliance year, the cost of compliance for renewable energy would be 4.69, and the cost of compliance for PV would be 1.28. If you add Bloom to the renewable energy calculation, that cost goes up to 9.86, and the solar remains at 1.28. So I just wanted to give that as a point of reference for the commission.
Well, nobody disagrees with that.
Well, I think that whatever the figures are, the figures are. I don't think there's a dispute over the figures. So
Just-
if Bloom is by law includable in the calculation, the figures will be as you stated.
Just to clarify, Mr. Chair, there are two steps to the DENREC process. One was the calculation, one was the process by which the director chose to exercise his discretion. And that's where the benefits came in. I just want to make that clarification.
Thank you.
So-
I'm sorry, under rules that are no longer relevant.
but at the time, they were.
Okay, thank you all very much. Commissioners, any comments? Commissioner Gray?
Thank you, Mr. Chair. Just 30 seconds. I'm thinking that someone brought up the idea of a turkey. So I've been sent down to the supermarket to buy a turkey, and it's going to cost me $10. But I'm told I can substitute Cornish hens. So I'm going to get 6 of them, and they cost $10 a piece. at the end of the day, I leave the counter and it costs me something. And so, again, I'm sidestepping the issue of who has discretion and the authority to make a decision. But I think it's critically important to make sure that the right parameters are going into an informed calculation around which the decision is being made. And I can't help but still look at the typical ratepayer's bill and say that there's an impact here. And I think that at minimum, the commission can take a step, and I would recommend to include the Bloom charges in this calculation as to the total cost. Now, we get down the road and the decision needs to be made, the discretion needs to be exerted. That's another question and another subject for discussion.
Commissioners, I think that when the comments are over, I think we want to go at the issues list 1 to the end, which is 3, I believe. Does anybody have any comments with respect to the definition of total retail cost of electricity? While we're thinking, apparently, I'm just going to make a general comment, and that is that with respect to Bloom, Bloom is in the law, and Bloom has been getting some subsidies from the, unfortunately, only from Delmarva Power and Light consumers for a number of years. I am certainly not an anti-Bloom person. I wish Bloom every success. I think they've done reasonably well in a very bad economy, and there are some good signs for Bloom, and hopefully they're going to be a big success. On the other hand, I'm going to be basically supportive of the DPA position and Mr. Myers' position, because I do believe that if we rule in favor of what staff wants, especially what DENREC wants, it will be obviating one very important object that the legislature put into its legislation, which is some check and balance against the discretionary, against this whole situation where it could go on as Mr. Myers describes. But it also, I might as well keep on talking since nobody else is right now.
I'm ready.
Commissioner
I'm ready to comment
Drexler.
on, we're still looking at the first operative question.
Yes, ma'am.
Okay. What has resonated with me the most and regarding the first question, what should be included in the total retail cost of electricity, is Mr. Delos's comment about, can you hold an electron in your hand? And the tire analogy, and that is, and I agree with staff's position here, and DENREC's as well, that supply, transmission, and distribution should be included when determining the total retail cost of electricity. And I'll move to Bloom as well.
Why don't we vote, we'll vote on these at one
Vote on
at
the
a
first?
time?
Okay.
Do you want to make a motion with respect to that? So we can discuss it further?
Is everybody ready? I'd like to make a motion that we support staff's position and DENREC's position on the first question regarding what should be included in the definition of total retail cost of electricity.
I second.
Is there any discussion? Anybody, any commissioner wish to discuss that? I disagree. I am in favor of the DPA position and Gary Myers' position, at least so that distribution charges should not be part of the total retail cost of electricity. Anybody else have any more comments?
Point of clarification, if with a question. Distribution charges here would be a third party who's simply a broker in the process of the transaction.
Delmarva Power and Light delivering electricity.
But
Their
when,
distribution charge.
The cost of delivery of the power to the customer.
right, okay, okay.
See, I don't think that is part of the for retail electricity supplier. My opinion. No further discussion. All those in favor of the motion signify by saying aye.
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 I heard 3 ayes. Commissioner Korea,
Yeah.
Commissioner?
No, didn't say.
Okay. 3 ayes. Anybody opposed? I'm opposed.
I'm opposed.
I can't be an abstention. It passes 3-2. Number 2 is the issue with respect to the inclusion of Bloom. I move that the cost of the Bloom QFCP energy output be entitled, in other words, in favor of the DPA and Mr. Myers' argument. Is there a second?
I second.
Is there discussion on that motion? All those in favor of the motion signify by saying aye.
Aye.
Are there any opposed? Are there any abstentions? The motion carries. The third issue is a discretion issue. Is there any more comments, or is there a motion with respect to that, so we can maybe talk about it some more?
I have a question, Mr. Chair, on the DPA's position, revised regulations have satisfied issues, revised on which date? Roughly, month, year? Because I think they may have been revised a couple times.
Well, we had taken a position in the first set of comments that we made, and then when staff republished in August, well, when you republished them though, it was in the August or September register, I think we were satisfied with what got published. So if there have been any changes since then, and you're shaking your head yes? Well, when were those changes made, and where are they?
This is the point I wanted to bring to the table. I'm not sufficiently clear which revision is being put forward here,
Apparently,
so.
neither am I.
Yeah.
Point of clarification. On August 1, in the August 1 Register of Regulations, the proposed rules approved by the Commission in Order 9090 said that DENREC would have final discretion, but those regulations qualified DENREC's submission as a final agency action under the APA. Responsive to DENREC's comments, subsequent comments, the proposed final regulations that have been posted with today's agenda that staff is supporting remove that requirement under the APA for DENREC, but shift the discretion back to the Commission. And under the proposed final rules, the Commission would have the ability to deliberate over DENREC's determination, and then the Commission would decide whether or not to freeze the RPS. And I'm open to clarification if anyone else has it better.
Those are satisfactory to the DPA.
You don't want to ask me.
I think you made yourself perfectly clear. You're saying that the word may means that that there's still an obligation there. It's not the permissive, as Ms. Cotta said. We understand that pretty clearly, I think.
I would concur with staff's opinion on this one.
You want to make a motion?
Move that on item number 3, E&C director discretion, that we go with the position put forth by the staff, The commission will be determine by order whether to adopt the E&C director's determination after consultation.
I second it.
Discussion on the motion.
Yeah,
Commissioner Drexler.
point of clarification, does that mean the commission will determine by order whether to adopt the determination to freeze after the determination's been made?
Mr. Lewis?
I can clarify. So, essentially, as I understand it, and the other parties may have something different, if you support staff's positions, you'll be supporting, with respect to that issue, the proposed regulations for this agenda. So, I can just kind of go through it real fast, step by step here. So, if the E&C director's calculations, in accordance with what's set forth in the regs, determine that either the 1 or the 3% requirement is met, then the commission shall conduct a consultation between the E&C director and the commission as to whether a freeze of the yearly increase, essentially a freeze, should be initiated or not. Then, 20 days after that consultation, the E&C director will submit to the commission a written determination, including the basis for that determination to declare or not declare a freeze. Then, at the next regularly scheduled commission meeting, the commission shall consider the determination and issue an order to the CREC as to whether to institute a freeze. So that statement right there, from the position of staff, would mean that after a consultation, the commission would issue an order whether to freeze. If they would like a freeze, they would issue an order. And if they don't want a freeze, they would similarly issue an order. And either one of those would be final agency action and therefore appealable.
Thank you.
Thank you.
Can I make one comment?
Yes, ma'am.
So essentially, staff's position that the commission isn't consulting but could veto DENRAC's determination whether to institute a freeze or even amend it.
The commission will be offering its advice to the distribution company under its jurisdiction with respect to RPS compliance.
So they could veto DENRAC's decision
Yes.
not to make a freeze or to freeze.
Yes.
You know, it seems to me that it's either that way or the Myers way, in my opinion.
Mine's easy.
So, I'm sorry, you made the motion? Are there any more comments on the motion? All those in favor signify by saying aye.
Aye.
Any opposed? I'm opposed. Any abstentions? Motion passes. Mr. Walsh, are there any other decisions we have to make in this docket?
Chair Winslow, I certainly hope not. I'm thinking
Publication notice?
we're going,
Another discussion on notice?
The rules will have to be republished because,
we've got a bit of a bifurcation here.
yeah, the Bloom, the decision that you made on Bloom is, you know, a substantive change to the rules that were published for comment. So they'll have to go out for publication again and another 30-day period. But I think the next time that they come before you, they would come before you as final regulations.
Assuming Ms. Iori drafts them correctly as to the Bloom.
Well, I believe that
Revision.
I had already proposed draft regulations, and I think what I heard was that the DPA's position was adopted, so I've already got them. Check out our comments.
We're fine with that.
Is there, okay, so that concludes that matter. Thank you to all the parties for their fine work. Is there anybody here from the public that wishes to make any other public comment with respect to assistance to us as commissioners? You see, we've got some strange faces, not that they're strange people, but some strange faces. If you want to come up and say something, feel free to do so. Go ahead, sir, come on up.
Commissioner, I mean, I'm not sure where I stand at this point.
How about sitting over here right in front of us? You have, you're welcome Just tell us what your name is and,
I was gonna speak and then I wasn't gonna speak, so,
for the purpose of the record, please identify yourself.
yeah, I will. So, Commissioners and Mr. and Mrs. Lady Commissioners, my name's Alan Rogers. I'm with the Chemical Industry Council of Delaware. I'm also the plant manager of the Keeney Company in Delaware City, Delaware. I just wanted to say thank you for letting me speak this afternoon and inviting me up here. My point is now that all these decisions have been made, why would the legislators have included cost caps into the legislation of the REPSA if they weren't intended to be followed? So I like the decisions I heard today, so I appreciate that. And also, why would the qualified fuel cells even be implemented into the REPSA if they weren't intended to be included? So those are my comments, and I appreciate hearing them. Thank you.
Thank you, Mr. Rogers. I don't see anyone else who looks like they wish to make any comment, so we have some brief director's comments.
Chairman Winslow, Commissioners, I certainly would intend to make my comments very brief to you. This has been a day of very clear wording, but I would also point out that it's been a little bit sticky. And in recognition of that, I'd like people to know that it's National Cotton Candy Day. Our next commission meeting will be on Thursday, December the 21st, starting here at the Dover office at 1 o'clock. Thank you.
Thank you, Mr. Howard. Thanks, everyone. We're adjourned.
Thank you.